hearings haven't started yet. All right, those were some key moments from this morning. The state resting eventually its rebuttal case. And now we are just waiting for those closing arguments to begin. Still with us, National Trial Attorney Michael Jaafar. Michael, I was taking a quick look through the notes of voir dire to see if I saw any questions about someone being claustrophobic, and I did not see anything. So basically, defense counsel was asking, has anyone been in an abusive relationship? Do you feel that you have a right to defend yourself? And so we saw a lot of those questions, which of course are important in voir dire.
That's a major mistake. I'm glad you told me that because I was trying to see if I could find it. Kelly, I'll tell you, I think my colleague Owens, our colleague, acquitted himself very well. I think he built a nice national following. I'm sure his phone is ringing off the hook. I will say one thing that now that you've told me that's a major mistake. And I don't know him, if I were to bump into him before this trial started, I would have told him, make sure you ask every single juror, are you claustrophobic? Because anyone who says they're claustrophobic should not be on that jury. I'm telling you right now, Kelly, I do not deserve to be on that jury or any jury where claustrophobia is a thing. Because if you're claustrophobic, you've closed your mind before this trial begins. The minute you see that a person's in a suitcase, you want to get out of that courtroom. It's hard for me to even see that video, right? So that's a major mistake. I can't believe you told me that he did not voir dire anybody asking them, are they claustrophobic? Because what matters at that point? If you're claustrophobic and there's nothing a person could do to you if you're claustrophobic to justify being in a suitcase and asking you to get out. Just so you understand the gravity of it, people who are claustrophobic cannot sit for an MRI. So if somebody on that jury is claustrophobic, they've been asked to do an MRI, and they've said, I would rather die. I'm not going to sit for this MRI, which is safe. Being in a suitcase and adjudicating and passing guilt or innocence on a fact pattern where somebody's in a suitcase, wow, that's a major mistake. But Owens, he did a fantastic job in this case. Look at the things he did. Just look at the fireworks in the courtroom earlier this week on the issue of the expert who had a deposition and did not disclose certain things to her, changed her opinion later on. I mean, look at the fireworks there. I think that lasted for 2 hours of him arguing with the judge and the judge relenting to some of his requests, right? So he did a fantastic job in this case. But that thing, the voir dire, not asking about claustrophobia, wow, that's amazing. Sometimes the most obvious thing, sometimes we as attorneys just miss.